Today we will talk about training number 1 of Companies Method. It's an overview of new Companies Act. Sorting out the guidelines, the practice notes, the rules, the regulations, and so on and so forth, including coming up with the e-portal. So things are still very fluid. We do not know what is coming. So we will need to keep a lookout all the time as to what is developing. All right, so let's start. Without further ado, or rather 100% of the shareholders or members to sign the circular resolution for it to be effective. But going forward, this rule is abolished. That means you go based on the required majority. That is for simple majority for ordinary resolution, and then the 75% remain at 2, the minimum. Okay, so once you have incorporated a company, means that you have separate legal entity, perpetual succession. All right, and what does that mean? It means that you are separate from the company. You get the protection from the liability, carried out the transaction, but at the point of entry, all right, such a person can also be charged. All right, and also the offense of officers is also extended. That means if he or she has knowledge, all right, that means he's not carrying out the transaction, but he has knowledge, or he knowingly authorized such a transaction. So you basically need to set up a different control form, okay, to follow the date of incorporation rather than the year end. Okay, so there are a lot of changes. So we really need to sit down and think of what are the, from start to the end as to what needs to be done. Okay, and at the moment you can only do this much. That means look at the constitution whether changes needs to be done. You can adopt the company's bill wholesale, and then also start putting in all the date of incorporation so that you can monitor the anniversary date for you to lodge in your annual return. Okay, and then keep yourself abreast with all the changes that is coming. Okay, all right. Thank you. Business continuity and succession after death or incapacity, especially with the new Companies Act, which allows one director and shareholder situation. All right. In the law, there is a need to have a next of kin. All right. So this next of kin will actually, whether one next of kin, two next of kin, or whatever, we still need to clarify on that. But there is a need for such company with a sole director, sole shareholder, to appoint a next of kin so that this person can actually step in the event that the director, due to death, due to incapacity, due to so many other. Okay. So after that, can you see here? Happy. So till the end is a good session. Happy.